Okay, thank you. We continue today with introduction to criminal justice. As you know, last week we started the criminal justice process. And we stopped at the level of the preliminary examination. The preliminary examination is the stage where you have the defendant requesting the person. Defendant, when we say defendant, it means the person who is accused of a crime that is before the magistrate court or the justice of the peace court, for instance, and asks the court that he wants a preliminary examination. It is provided for in the criminal procedure law. The Liberian criminal procedure is only in chapter 12 of that particular law, and specifically section 12.2, which gives the right to the defendant, the person or persons accused of criminal offenses, can ask the magistrate to order the conduct of a preliminary examination. The reason that the accused person asks the magistrate to conduct a preliminary examination in a case that the magistrate, though, does not have jurisdiction, is simply he wants the magistrate to determine whether there is a probable cause that exists for even for the issuance of the writ of arrest. If the defense or the person accused believes that the state or the prosecution does not have reason to issue the writ of arrest against him or her, he can ask the magistrate to conduct a preliminary examination. And then when he asks the magistrate to conduct a preliminary examination, the magistrate will order it based on his request. It is only the defendant. In other words, it is only the person who is accused of a crime that has the right, the statutory right, to request the magistrate to conduct a preliminary examination. Preliminary examination can also be conducted in a circuit court, but the only circuit court that the preliminary examination can be conducted is the rape court or the circuit court in any of these counties that is conducting a rape trial. It is only in the rape court that a circuit court can conduct preliminary examination. Magisterial courts do not have authority to order the preliminary examination in a rape case. Authority. But the magistrate courts have the authority to order the conduct of a preliminary examination in other cases except for rape cases. Let me say that again. If the case is a rape case, it is only the rape court that has authority to conduct preliminary examination. Magisterial courts do not have jurisdiction to conduct preliminary examination in rape cases. And in the counties, only the circuit court can conduct preliminary examination. In the counties also, the magistrate courts do not have jurisdiction to conduct preliminary examination. The circuit court is the one that has the authority if the circuit court is hearing a rape matter. Because unless there is a rape court in that county, like one county, but in most of the counties there is no rape court. So the circuit court in that county conducts preliminary examination and can hear rape cases. So we come to Mosurada. In Mosurada, it is only criminal court E that has jurisdiction to conduct preliminary examination based on request of the defendant. Magistrate courts do not have jurisdiction also. Now, it is only the defendant, the person who is accused of the crime, that has jurisdiction to conduct the preliminary examination. It is only the defendant. In that case, the only reason for the purpose of requesting the court to conduct preliminary examination is if the defendant, meaning the person accused of a crime, believes that there is no substance in the allegation against him that form the basis for the issuance of the writ of arrest. So he is asking the magistrate court to conduct a preliminary, to listen to the witnesses that the prosecution has and listen to their testimony and to determine whether their testimony show any reasonable ground or belief that indeed the issuance of the writ of arrest against the accused was right, was based on probable cause. Here the magistrate conducted a preliminary examination, and the magistrate believes that the hearing process shows to him that there is no probable cause, there is no reason of law and fact for the issuance of the writ, then he can dismiss the case. And that will operate in favor of the defendant, the person accused of the crime. And that's the reason defendants ask for preliminary examination. Now, at the level of preliminary examination, it is only the prosecution that has the authority to present witnesses. The defense team does not produce witnesses. What a defense team can do, meaning the lawyer representing the person accused of the crime, will only cross-examine the prosecution's witnesses that they will bring to testify. And then after that, they can argue, and the magistrate will make a ruling to say, look, based on the argument and the evidence produced, I have reason to believe that there is no probable cause. I'm dismissing the writ. Or he can say, based on the evidence and the argument, I have reason to believe that there is probable cause. So I will send the case forward, and the defendant will remain under the power of the writ to answer further. That's what the conduct of the preliminary examination is. So that is its stage. After initial appearance, they have it. When the magistrate believes that the preliminary examination holds, what next he can do is that he will send the case to the court for indictment. The court for indictment is criminal code A for criminal code A. When they send the case, it means he's saying that it will remain under the jurisdiction of the court in the writ, and then he will transfer the case to the appropriate court. For Monserrato, he will transfer the case to criminal code A. If it's in the other counties, he will transfer the case, the magistrate will transfer the case to the circuit court. The circuit court is the one that will prepare the indictment and issue the writ. In the counties, the circuit court will hear the cases, all the criminal cases. And unless there is a specialized court in that county, that's the only way the circuit court alone will not hear that case. That is how it happens. But if there is no circuit court, if there's a specialized court that has equal or concurrent jurisdiction with the circuit court, then the circuit court will assume jurisdiction over all these criminal matters. Then that brings us to the next stage. When the case is transferred to the court for indictment, that case goes straight. So you see the next stage there, you see indictment or bail of arrest. This stage is where the case goes to the court for indictment. When the case reaches to the appropriate court, therefore, Monserrato to criminal court A, in the counties, it will go to the circuit court. But for Monserrato, it goes to criminal court A. Criminal court A will prepare the file and send the file to the office of the county attorney. The office of the county attorney will be the one that will take the file and review the file and prepare the draft indictment. That draft indictment, which is not the indictment, but it has to do with the affirmation. The county attorney will prepare the draft indictment that will outline all of the elements of the crime. What happened? How it happened? How the crime was committed? Who committed the crime? What is the date that the crime was committed? Why the crime was committed? With what the crime was committed? All will be contained in the indictment. Then the indictment was also contain the provision of the penal law that the particular defendant had violated. When he prepares that particular draft indictment, he brings it back to criminal code A for Monserrat. If it is in the counties, it will be in the circuit court. And then there will summon certain kind of people we call the grand jury. The grand jurors are the people from the communities, like those jurors who sit in trial cases. They are different from grand jury. The grand jurors are the same people from the community who sit to listen to the case, to listen to the witnesses that the prosecution will present to them. Based on the draft indictment, they are verdicts that the prosecution, the allegations that the prosecution has developed against the defendant. In that case, the grand jurors will listen to each and every one of the witnesses that the prosecution will present. When they listen to the testimony, those grand jurors, if they believe there is a reason for them to believe that the person accused of the crime has committed the offense, meaning if they establish that there is a probable cause to believe that this person has committed the offense, then they will vote on the draft indictment. When they vote and they get a majority to sustain the decision that indeed the persons accused of the crime should be indicted, then they will sign it. It becomes what we call a true bill. When they sign that indictment and they vote, they got the vote, and then you find the four men or the four ladies signing the indictment. The four ladies is the or the four men. These are kind of people who are the head of the grand jury. Then the secretary will sign. When they sign that particular indictment, they return it. Then the county attorney will sign. The clerk of the court will also sign. When it is done in that way, it is called a true bill. That true bill becomes the indictment. It becomes a formal allegation that the grand jurors have returned, accusing the person that there is reason to believe that you committed the offense, and you must have your day in court to answer to these charges based on the allegation, based on the evidence presented by the prosecution or the state. When that indictment is returned, then criminal code A, if it is in Monserrat, will transfer the whole file with the indictment to the appropriate court. If the case is a theft-related matter, then the file plus the indictment will be turned over to criminal code C if it is a theft-related matter. If it is an armed robbery, it will be turned over to criminal code D. If it is a rape case, it will be turned over to what? Criminal code E. Now, for example, if it is a theft-related matter, the whole file and the indictment will be turned over to what? Criminal code C. Then criminal code C will now issue the writ of arrest and attach it to the indictment, giving criminal code C the jurisdictional authority to issue the writ of arrest. That writ of arrest will be attached with the indictment, and then the sheriff of the court will proceed to serve the person accused of the crime with the writ of arrest and the indictment. When the arrest and the indictment have been served to the accused, meaning the person accused of the crime, then it means that that trial court, the criminal proceeding, has now assumed jurisdiction over the person accused of the crime. In the absence of that, the court has not assumed jurisdiction over the person accused of the crime. So the only way a trial court can assume jurisdiction or exert jurisdiction over the person that is accused of a crime is when that particular person has been observed that and that particular person has been served with the writ of arrest. That is how it is done. So the service of the indictment. So that is it. That is how it is done. The indictment. But if the grand jury, for instance, observe that look, even though we are serving this particular person, but we observe that this particular person, even though we are listening to the evidence direct by the prosecution, but we don't believe that this person could be held liable for the crime, then obviously you have a situation where the grand jury will return what we call the bill of ignoramus. The bill of ignoramus is the bill where it means it is a response that the grand jury gave. The grand jury gave and say, look, it says, look, we don't have reason to believe that there is a probable cause for the person to be indicted. So we will not issue it. But that does not mean the prosecution will not still try to convene to continue to call in all of grand jurors to hear and in all of the issues. That's the power of the state. Let's look at the next stage after the indictment has been served. It's the service of the indictment in the writ of arrest. The service of the indictment in the writ of arrest have to do with what? The writ of arrest, as I told you initially, when the indictment has been issued or returned by the trial, by the grand jury, that indictment, that particular indictment can never be served on the accused person except the court that has trial authority over that particular case issues the writ of arrest. So when the grand jury has come with the indictment, and criminal code A, for example, in Montserrat, comes out with the indictment, criminal code A is not the one that can issue the writ of arrest. Except criminal code A is the trial court with the trial jurisdiction. Therefore, instead, if it is a murder case, then criminal code A is the one that will also issue the writ of arrest. But if it is a theft case, criminal code A does not have jurisdiction to issue writ of arrest. So criminal code A will always transfer that case to the appropriate court that has trial jurisdiction. See, it is a theft-related matter. The appropriate court that has trial jurisdiction is criminal code C, if it is in Montserrat. But if it is in the circuit court, meaning the courts in the counties, it will be the circuit court in the county that will issue the writ of arrest. So for Montserrat, they will go to criminal code C. It is criminal code C that will issue the writ of arrest and attach it with the indictment that came from criminal code A and serve that indictment on the accused. The writ of arrest and the indictment have to be served on the accused person, and that person will receive the writ of indictment and sign for it. Then the sheriff will now go back and make a return on the writ of arrest and say that the indictment has been served on the defendant. It means now that the court has proper jurisdiction over the accused person. That is how it is done. So that is the stage after the indictment. You talk about the service of the writ of arrest in the indictment. That's the stage there. Let's go to the next stage in the criminal process. The next stage in the criminal justice process has to do with the motion for discovery. What is the motion for discovery? The motion for discovery is when you have in the trial process, they will always serve the defendant the writ of arrest. The defendant will receive the writ of arrest, meaning the accused person, and then will give it to the lawyer. The lawyer does not sign for the writ of arrest and the indictment on behalf of his client in a criminal case. No way. Only in civil cases, the client can authorize the lawyer to sign for it. But in criminal cases, it is public. The sheriff will always say it's personal self. Yes, it's personal self. You got to serve him the indictment, and the lawyer will take the indictment. Now, when that is done, the defense lawyer who receives the indictment for his client will now have the authority and the responsibility to ask the court, the trial court that has jurisdiction, to ask the trial court to order the prosecution to turn over all of the evidence that the government has against the accused. That is how it is done. So, in substance, the trial lawyer, the criminal defense lawyer, representing the accused, will file a request to the court, which we call a motion, asking the court to order the prosecution to turn over every evidence in the favor of the defendant, that will operate in favor of the defendant, which we call exculpatory evidence that can incriminate the defendants, incriminating evidence, everything they have to turn over, everything to the defendant's lawyer. That request that is done by the defense lawyer is what we call the motion for discovery. That's the essence. The motion for discovery, you say, order, we asking the court to order the prosecution to turn over the defendant's witnesses, the police report that contains the voluntary statements made by all the witnesses, the police charge sheet, the police investigative report, everything they have, and the copy of all the evidence they have, to be turned over to us. We want to analyze it in order to put us in the position properly legal for us to respond to the what? Arraignment. To respond to how we will plead when the charges are read to our client. It is a constitutional right under the doctrine of discovery, which we call notice in constitutional law. So, under the Constitution of Liberia, it says that the defendant, under Article 21, it says the defendant has the right to notice of the charges against him and to be informed of the nature of the offenses against him. So, that is what the law says. And it is on that basis that the criminal procedure law requires, the practice requires, that the person must be accused, must be served. Now, discovery is not actually mentioned in our criminal procedure law because our criminal procedure law is archaic, meaning it is old. It is very, very old. We need from some reforms in our criminal procedure. Our criminal procedure law does not actually. Our criminal procedure law does not actually say that the defendant must be turned over, all this, but it is because of our practice under our practice, what we call the common law practice, and the receptive statute practice. We copy from the American jurisprudence. And also our constitution that talks about notice as a cardinal principle of law. The person being informed of all the charges, the notice, and the information. So we use that. But the criminal procedure law needs an amendment, a particular amendment in the provision that will require for discovery, as it is done with the federal criminal procedure in the American jurisprudence that we copy from. So I think as time goes by, maybe the legislature need to work on that they can do some amendments in the criminal procedure law, specifically in this era of chapter 16 or 17. So that is how it works in our practice of law. And then you turn over all the evidence. At the end, we have the opportunity to review the evidence. Because if you don't turn the whole evidence over at this stage, you cannot, during the trial, bring them. Because trial is not ambush. The process of law is not ambush. It's about what? It must be open and transparent. So it's nothing like hide and seek, our criminal procedure. Any witness that you have against the person, the defendant, that will be testifying against the defendant, that witness identity and address must be known to the defendants and their lawyers, so that they can be able to prepare themselves to know what the witnesses have said against your client in order for you to be able to cross-examine under the due process requirement of Article 20 of our Constitution, and as well as Article 21 of our right to notice and cross-examination under the law. So let's start there today. We start to discover in our criminal justice process in the Liberian criminal justice system. This is how the Liberian criminal justice system works. This is also how the American criminal justice system works that we copy from. So we'll be teaching it in a way that the simultaneously will be teaching it in parallel with the American criminal justice process, the American jurisprudence, the federal jurisprudence, and the Liberian justice system. Thank you for listening. And we'll stop there today. We'll end this class for today. The next time we come, then we'll start going to the other steps. So we start today on discovery. Good day.